Thank you, Sundahl, and it's an honor to be speaking to such an august group and to be following in particular Jim Caravala, whose presentation I've seen other incarnations of, and I believe it is the most persuasive presentation regarding the unstoppable nature of the space resource industry, the necessity for the space industry, space resource industry, and the economics of it. I think we can all agree that there is no way for mankind to achieve a permanent foothold on celestial bodies, be it the moon, Mars, or others, without extracting natural resources from those celestial bodies. And I think we are determined as a species to achieve that interplanetary goal. And I think we are determined this generation to do it. So we'll move forward. But there are, of course, business practicalities, as Jim has pointed out. And my presentation will focus more on the, I'm just starting my timer to make sure I don't go over, as I tend to find it hard to stop once I get going, but I'm going to keep this short and sweet because I look forward to the forum. But what my talk is going to focus on are the legal anchors to the business case, the legal necessities for the business case of resource extraction. And the title of my presentation is Staking a Claim, What Investors Need to Know. Because I think one of the primary questions of any investor in
Mark,
the
do you have a
resource
slide
extraction
to share?
Yes.
Do you have a slides to share?
I do not. I do not. Not
Okay,
at this
fine.
point.
Okay, it's
No,
fine.
no.
Yeah,
I'm just I find them to you know, unless there's a real need for them, I think they tend to distract.
Okay.
I'm going to try
No
to
problem.
make my words to the point here, but I hope to keep your attention through my presentation here. But again, the title of my presentation is Staking a Claim, What Investors Need to Know. I think, again, one of the primary questions that investors are going to ask is, how do we protect our investment? Is it possible to stake a claim on the moon once we have identified resources? Is it possible once we've prospected remotely and perhaps found a valuable deposit of minerals, be it ice or metals, is it possible to stake a claim to protect that deposit from other space actors that might get there before we do? If we cannot protect that, investors will be reluctant to invest the money that's needed in order to achieve that. So can we stake a claim? Can we protect that deposit of resources before we arrive to exploit the claim? Likewise, once we begin, are we able to continue without interference from other entities? That is one of the big legal questions. And Jim and I both participated in the Hague International Working Group on Space Resource Governance. And that working group, and one of the building blocks, did call for the creation of some type of priority system that would recognize the priority rights, the resource rights, as it put it. But do we have that mechanism yet? Do we have a mechanism for staking a claim? And this is the answer. Yes and no. We do have certain protections in place. We need more. We need greater clarity. But we're not going to have that clarity anytime soon. And the technology and the businesses are moving forward at a greater rate than the law is evolving. I think that is a fact. And it's somewhat to my chagrin and my shame as a lawyer. And I remind my fellow lawyers about it, that the technologists, the engineers, and the entrepreneurs are outstripping us and doing the impossible, while we as lawyers and policymakers have a hard time just deciding on a couple of words to create the legal framework. So we have some ways to go. We do not have the crystal clear priority system in place that we have in terrestrial mining operations, where you're able to prospect, gain rights to prospect. Once you have discovered a deposit, to assert a claim, so you can then develop the technology and the infrastructure to exploit it, and then have priority rights, exclusive rights for the exploitation of that mineral deposit for a certain amount of time. Now, we have those laws in place terrestrially, but not celestially. So we're working on that. And we know that everyone should know that the United Nations, the Committee on the Peaceful Uses of Outer Space, just launched a formal working group to deal with space resources. And priority rights will be one of the issues that's taken up. At least we have reached the consensus and the legal clarity that resource extraction is legal. And I think we're all pretty clear on the fact that ownership of extracted resources can exist and will be protected by domestic legal systems and not be challenged on the international level. I think we have reached pretty clear consensus on that, with perhaps some outliers, but with the domestic laws of the US, Luxembourg, Japan, and the UAE explicitly clarifying the right to engage in this activity. I think we have overcome that obstacle. But now the question is, how do we give the certainty, the protection, the ability to stake a claim, the certainty, the clarity that is required by investors in order to unleash the capital that's needed to actually execute the entrepreneurial vision. We have work to do. We don't have it yet, but this is my next important point. That we do have already good laws on the books that can provide at least an interim system for staking a claim or of acquiring some protection. And I think with the proper lawyering, and I think it's important for companies that are engaged in this to make the case and to have the clarity to explain to potential investors that there is this protection and understand where it comes from and what the companies must do in order to maximize the protections that are available. I think it's very important to get clarity on that. And I'm going to give you my 5-minute overview of where these protections lie and how they work and what the companies must do in order to avail themselves of these protections. All right, first of all, there are protections that exist on a domestic level and then protections on the international level. So if you are a company in any given country, whether it's China or the United States or Luxembourg or South Africa, wherever you are, you will want to have protection against other companies, other actors from your own country. But you'll also want protection against other actors from other countries. Now, I'll look first at protection against other actors from your own country. And I will use the United States as an example. Where do these protections lie? They lie in the conditions placed on launch licenses. When you receive a payload review and a launch license from the Federal Aviation Administration, you will make clear that your plans are to engage in resource extraction in a particular area of the moon, let's say. Now, any company afterwards that applies for a launch license, any American company, and this is required for any US company, even if they launch from another country, but any US company now will have to apply for a launch license from the FAA, from the same agency. And I do believe that the FAA would impose on any subsequent applicant, when they grant this subsequent launch license, a condition that you do not interfere with the operations that were licensed before to the original company. And those subsequent actors, those subsequent US companies will have to comply with those conditions, so otherwise have their license revoked or face penalties. So that is where the protections lie domestically, in launch license conditions. Now that gives protection for a US company against other US companies or other companies that launch from the United States. But what about a French company or a company from Japan that is licensed in Japan or in France? They will not be subject to the conditions of the FAA. And so where do the protections come from? And those protections come from a different place. They come from the Outer Space Treaty, which requires in Article 9 that every country and by virtue of every country, every signatory to the Outer Space Treaty, must make sure that all of their nationals as well. So every Japanese company, France must make sure that every French company, Japan, that every Japanese company operate in a manner that exercises due regard with respect to the corresponding interests of all other actors. And therefore, it would be a violation, in my opinion, and I don't think I'm alone in this, it would be a violation of the Outer Space Treaty for Japan or France to approve a launch license for their companies that would interfere with the mining operations of a US company. There's also, of course, a requirement under Article 9 of the Outer Space Treaty to engage in consultation if there's potential for harmful interference. And there is, under general international law, a prohibition against harmfully interfering with the operations of another country. So those are the international legal hooks on which we can now hang our protections against interference, through which we can now, in a sense, stake a claim. Now the question is, okay, once you understand these legal mechanisms, how should a company best avail itself to ensure that it receives the protections that I'm promising here? And there, I think it has, that hinges on the sharing of information, because the FAA can only impose conditions preventing another company from interfering with your activities if the FAA knows what your activities are. So you need to make clear to the FAA, this is what I'm doing. Please ensure that when you grant future launch licenses, you make sure that no one interferes with our operations. And the other countries, the licensing agency in Japan or in France or in South Africa, they're not going to be able to act with due regard or to avoid interference with your activities if they don't know what you're doing. And so you must share information. And this is a paradigm shift. And it is connected to another project that I'm working on, and you'll hear more in the law and policy segment of this gathering from Antonino Salmeri, who is my partner in the Article 11 project. I don't mean to get into the weeds here, but our proposal is that the existing registry that is operated by the United Nations pursuant to Article 11 of the Outer Space Treaty, which requires states to share information about their outer space activities, that we use that registry to share information. And so we would encourage companies to share the information with the registering authority, that would be the Department of State in the United States, via the FAA perhaps, to share with them information about their proposed activities or their existing activities so that it is submitted to the United Nations through the operation of Article 11. It is made a matter of public record, and then the United Nations, the Secretary General, has the affirmative obligation to disseminate such information. That is how we can get the information out to the world, thus triggering this duty to operate with due regard and to avoid interference. So the sharing of information, and this is a paradigm shift. Companies view the sharing of information as a burden, something to be avoided. Companies fear the sharing of proprietary information. We must change that mindset. Sharing of information is no longer a burden in this respect. It is a benefit. And the more that you share, the more protection you will get. The more that you clarify what it is you're doing and how other entities may interfere, the stronger your argument can be that the other country has and other actors have an obligation to exercise due regard and to avoid interference. And so this is my view. This is my advice, although I'm of course not giving legal advice, but this is my, these are my academic musings for companies to share this information, avail themselves of these existing laws. And then we need to all work together to try to add to those existing laws to get even greater clarity. I will end this presentation with a comment about one of the obvious shortcomings of the existing this existing system. Is it possible to stake a claim to protect future activities? If an investor wants to invest $1 billion in your company today, because you have identified a resource deposit on the moon, but you're not going to exploit that for another 5 years, can you require other actors, can you prevent them from, once the word gets out about your discovery, if it does, can you prevent them from going and exploiting it before you do? Do the existing laws prevent that from happening? And I think that is not clear, but if that is going to work, again, I think the sharing of information, that if you make it public knowledge that you plan to engage in resource extraction of a particular area and you expect to go there in 5 years, I think for any country to allow one of their operators to go there and exploit it before you do would be a violation of the Outer Space Treaty. And it would be, even though your actions are perspective, you do have this perspective interest, and all other actors must exercise due regard with respect to that perspective interest. But that is one of the uncertainties with the existing system. So I've said enough. I hope it makes sense, and I very much look forward to everyone's thoughts and comments.